Coming to another law which is of great significance to a company in India is the Competition Act 2002. This act replaced the Monopolies and Restrictive Trade Practices Act of 1969, and it was found to be insufficient for the needs of the growing Indian economy after liberalization. The act has objects as: first, to prevent practices having adverse effect on the competition; second, to promote and sustain competition in the market; third, to protect the interests of consumers; and fourth, to ensure freedom of trade in the market. The Act establishes the Competition Commission of India, and its function is to regulate three aspects regarding competition. They are: first, prohibition of certain agreements under Section 3 of the Competition Act 2002. Under this provision, any agreement made by an enterprise or group which is made in respect of production, supply, distribution, acquisition or control of goods or provisions of services which causes or is likely to cause an appreciable adverse effect within India is prohibited. Such agreements are called anti-competitive agreements. Second regulation is regarding abuse of dominance under Section 4. This provision prohibits abuse of dominant position by any enterprise or group which will have an appreciable adverse effect on the market. And final is the regulation of combinations under Section 5 as well as Section 6 of the Competition Act 2002. Under it, mergers and acquisitions which meet the specified turnover or asset-based test laid down in the Act itself have to be notified so as to regulate them from hampering the competition in the market. Coming to another law which a company operating in India must adhere to is the Foreign Exchange Management Act of 1999. Now, this act was enacted to basically promote the foreign exchange market in India. It repealed the Foreign Exchange Regulation Act of 1963. By this new law, a paradigm shift has occurred in the foreign exchange policy of India. Earlier, it was about control and regulation of all external transactions, but now it has been replaced to management of the foreign exchange for better capital inflow. Now, FEMA Act of 1999 lays down rules regarding dealings in foreign exchange, holding of foreign exchange, foreign securities and any immovable property outside India, current and capital account transaction in foreign exchange through a person authorized under the Act, export of goods and services, realization and repatriation of foreign exchange, to mention a few. Now, the Act further lays down certain penalties for the contravention of the above rules. Now, coming to another law, the business of insurance is regulated in India under the Insurance Act of 1938. The companies which are engaged in providing insurance have to comply with the provisions under this Act. This is a comprehensive act relating to matters of insurance companies. Some of the provisions under this Act are regarding eligibility for transacting insurance business in India, procedure for insurance companies registration, capital structure of the companies, accounts, balance sheet, audit and returns of the insurance companies, meetings of insurance companies, liabilities of directors in such companies, investment of assets of such companies, and amalgamation, transfer or winding up of the insurance companies. Hence, any company which is interested in the business of insurance in India has to comply with not only the Companies Act 2013, but also the Insurance Act 1938. Now, tax imposed by Government of India on anybody who earns income in India. This tax is known as income tax. Now, this tax is levied on the strength of an act called the Income Tax Act, which was passed by the Parliament of India in the year 1961. The Income Tax Act is one of the core laws which every company in India has to comply with. Now, the income earned in India is not limited to income earned within the geographic limits or the boundaries of the country. Certain incomes are also deemed to have been earned in India, although they may have been earned outside the country. The Income Tax Act lays down various rules relating to resident for the purpose of taxes in India, special tax provisions for SCZs, deductions, computation of total income, as well as offences under the Act and penalties for contravention of the rules. It also establishes a income tax authority for carrying out the provisions under this Act. Hence, a company in India also has to be aware of the Income Tax Act. Now, India introduced a new form of business organization by the enactment of the Limited Liability Partnership Act 2008. An LLP or the Limited Liability Partnership combines the flexibility of a partnership and the advantages of limited liability of a company at a low compliance cost. LLP therefore provides its members the flexibility of organizing their internal management on the basis of a mutually arrived agreement, as it is in the case of a partnership firm. The LLP form of business vehicle is useful for small as well as medium enterprises. Now, the main features of the Limited Liability Partnership Act of 2008 can be briefly said to be: firstly, that the Indian Partnership Act is not applicable to LLPs. Second, the LLP has a body corporate and a separate legal entity from its partners. Third, the mutual rights and duties of partners intersee in an LLP, and those rights and duties the LLP and the partners are governed by an agreement or provisions under the Limited Liability Act of 2008. Fourthly, every LLP must have two partners and two individuals as designated partners, of whom at least one must be a resident in India. Therefore, any company or LLP must be well versed and comply with this Act of 2008. Now, another set of laws that a company, especially an industry, must comply with are the country's labour laws. These labour legislations regulate various aspects of the relationship between employers and employees in an industry. It regulates the health and safety of its workers, minimum employment requirements, employees' rights, to name a few. It is important for the corporate India to be aware of these labour legislations, as they have direct consequence on the working and regulation of the company. The term labour here refers to any productive work, especially physical work done for wages. I will discuss now very briefly the main labour laws in India. The very first and the most important labour legislation is the Industrial Dispute Act of 1947. The statement and object of this act is to make provisions for the investigation and settlement of the industrial disputes. The Industrial Dispute Act of 1947 was enacted to make provisions for investigation and settlement of industrial disputes and for providing certain safeguards to the workers. The Act contains about 40 sections which deal with defining an industry, industrial dispute, layoff, lockout, retrenchment, trade union, strike, wages and workmen. It provides machinery for investigating and settlement of disputes through Works Committee, conciliation officers, board of conciliation, courts of inquiry, labour courts, tribunal and voluntary arbitration. It also lays down provisions for reference of dispute for adjudication. Payment of wages to workers during pendency of proceedings in the High Court are also dealt with under the Industrial Dispute Act. Then what are the rights of appeal, settlement in or outside conciliation, notice of change in employment conditions, protection of workmen during the pendency of proceedings, strike and lockout procedure, layoff compensation, retrenchment compensation, proceedings for retrenchment and various penalties for contravention of the provisions under this Act. Now, another important legislation is the Employees State Insurance Act of 1948. This is a social welfare legislation enacted by the Parliament to achieve the socio-economic justice enshrined in the directive principles of state policy under the Constitution of India. Its primary purpose is to provide relief to the employees in case of maternity, injury during the course of employment, as well as at the time of sickness. In such situations, employees receive medical relief, cash benefits, maternity benefits, dependents of deceased workers receive pension and compensation for fatal or other injuries and diseases. It also establishes the Employees State Insurance Corporation. Now, coming to another labour welfare legislation, it is the Workmen's Compensation Act of 1923. The Workmen's Compensation Act of 1923 aims to provide workmen as well as their dependent reliefs in case of accidents arising out of and in course of employment which has caused either death or disablement of workmen. This Act, is to be noted, does not cover workers under the Employees State Insurance Act. The reason for exclusion is that they are already covered under the SETRO Act. Now, let us see some of the main provisions of the Workmen's Compensation Act of 1923. The Act deals with defining of a workman, disablement, then under what circumstances employer is liable to compensate, provisions regarding accidents arising out of and in course of employment, and provisions regarding the amount of compensation to be paid in various circumstances. Now, the final labour law that we will look at today is the Factories Act 1948. The primary object of the Act is to secure safety measures in the factories for the health and welfare of its workers, as well as create a system of approval method for starting of factories. This Act the major provisions of this Act can be said to be: first, that the Act defines what are factories, then it lays down safety and health measures, it lays down working hours, what are the overtime wages, records of workmen, facilities which are to be provided in large factories, provisions on women factory workers, rules of employment of children in factories, and also how to deal with hazardous processes in a particular factory.